Please be seated. Thank you, Ms Horton. Mr Futrell.
May it please the Commission. Horton, I just want to ask you about a specific area of risk that is dealt with in the remediation plan. And I'm sure you're aware that the Western Australian regulator has given a direction that prevents Burswood nominees from conducting junkets, privileged player activity and premium player activity in Perth.
Yep.
And the remediation plan has a reference to something which is referred to as the VIP business restructure. And it appears that that applies to Crown Melbourne and will in due course apply to Crown Sydney.
Mm.
I understand it doesn't apply as matters stand to Crown Perth. Is that correct?
Well, my understanding, Mr Futrell, of that part of the remediation plan, and it's a little while since I've looked at it, so, but my understanding is, as you would know, the VIP program, which was a source of considerable concern, that we basically have consolidated that into reporting into Crown Melbourne. It's all its staff are domestic, and it will deal with those premium commission-based players, which, given, as you've rightly said, there's an explicit banning of all of those types of play. Or I noticed from your regulator, those types of play aren't relevant to WA.
Assuming that there may be some relaxation of that regulation in the future, are there any circumstances in which you would advocate or contemplate the return of an international commission business in Western Australia, in Perth?
Look, can we make a distinction between junkets here, which I think no one has any appetite for? We've said absolutely, categorically, no way. And in terms of commission play in WA, it would depend on the attitude of your regulator. I mean, if we're permitted under regulations in New South Wales and Victoria to have a business of that kind, with all the appropriate protections, et cetera, if there is a change of that view in WA, well, we'd have to look at it. But at the moment, that's not the case, as you rightly observe.
So, regulation permitting, there would be an appetite for some form of international commission business in Western Australia.
If the protections are as we want them to be, and if it's consistent with the state's risk appetite, well, obviously we'd look at that, definitely. When
you mention, or when you describe or refer to protections, what do you have in mind in that answer?
Expended customer due diligence, and you would know that one of the issues with junkets is there being a remove in terms of who the people are and not necessarily being confident about all of their bona fides. So the arrangements in respect of the controls about the customer obviously are material into that part of the business.
And are they protections you contemplate within the Crown Resorts Group's own systems, or are you thinking of something in a more regulatory imposition of protections?
Look, my personal view, Mr Futrell, has always been that there are opportunities if the regulators, including law enforcement, wish to share more information, that we could do more. I mean, at the moment, we can do what we can do, and we're going to do a lot more than has been the case, as you well understand. But there are sources of information. Of course, you know, I have held, positive vet top security clearances in my time. I still hold a security clearance, and I'm very conscious of the information that's available to law enforcement and others, which is not available in a commercial context. So, I mean, if we were enabled to be informed in that way, that would be enormously, I think, advantageous to everybody, to be perfectly honest with you.
Okay, thank you. Can I just return then to a topic we were dealing with before the break, and that is, I think you've mentioned a couple of times, I may be misquoting you, or I've certainly read it in your statement, about a process of escalation of risk
Yes.
through the various frameworks.
Yes.
You dealt with this in the statement you gave in the Victorian Royal Commission, which, if you can, I'll assist you with calling it up. It's CRW.998.001.0152 and on pinpoint 0154. You dealt with this at paragraphs 34 to 47 of that statement, which is the, as I understand it, you're describing the process for escalation of risk through the frameworks, and there's a diagram there that sort of shows it in a pictorial way how it works. I take you have referred, I think, either in this statement or in the one you've given to this commission, to various policies and documents. One of which is something called the risk management policy, which is CRW.512.043.0051. And it may be not necessary to call us up. I'll just ask you a question about something in it referred to as a risk profile. And it indicates, if you're not familiar with this, I'll bring it up for you, but there's an indication there that Crown will have risk profiles in place across all material Crown businesses, including, amongst others, Crown Perth. Which document material risks to each business. And you may have, I think, already said something about this in passing earlier today. Then in the risk management strategy, which I will call up, which is CRW.512.041.0050 at pinpoint 0064. There's a sort of a diagrammatic.
You'll have to blow it up. I'm sorry. Eyesight, poor, age. That's better.
It'll help us all, I think.
Absolutely.
So this I think is sort of diagrammatically explaining what perhaps I just took you to the terms of the risk profile. So it appears if each business has a risk profile. Then Australian Resorts gets compiled into an Australian Resorts risk profile. And they all get compiled into a risk profile that goes ultimately to the Risk Management Committee. And so when the risk profile reaches the RMC, is the Risk Management Committee itself involved in the compilation of the various profiles, or is that done by management?
No, it's done by management. And as we discussed earlier, Mr. Futrell, you actually have a profile sub each of these business units as well. So there are some parts of the business that have been a greater level of focus. So hotels, for example. So they're not all, because each bit of the business isn't quite the same. I mean, gaming in Perth doesn't necessarily have the same risk profile as what goes on in hotels and restaurants, for example. So you've got a subsidiary component to this, if that makes sense. But in terms of the expectation, so we don't actually compile these as the committee. And when we talked earlier on today about my expectation about what the boards of each of these subsidiaries would do, they should be looking at this risk profile, right, for each subsidiary. Now, do I expect to see them? Ultimately, yes, because I want to be confident. And as we talked about earlier, you need to, just like the Deloitte survey, you want to look at the aggregate, but you also want to see the component parts. But the committee itself doesn't compile those products.
And so when ultimately there's a risk profile for the group, makes its way to the RMC, as I understand it. That risk profile will not have that level of granularity relating to each of the individual businesses, though. Is that?
Well, this is my point to you. I think actually it should show the group, but then it should show the elements of the group. And we do, when we actually look at risk issues, compliance issues, we don't just deal with them in a kind of homogenous whole. We like to see reporting against Melbourne, Perth, Sydney, Aspinall's, Betfair, etc. So we're actually seeing the elements of the change, not just there was a regulatory breach. I mean, it goes to the point that you made earlier about if you had 5 bad HR outcomes in Perth, 4 out of 5, you want to know that that's where it is. This is the same.
But as matters stand, it's not been reported in that way to the RMC, is it?
No, not at the moment. This is the point that I've been making about the work that's underway, and the profiles that have been done across these different elements of the business. And I said this in the Finkelstein inquiry. The material bits of the business have been done, but not every single component. Now, that might have changed, to be fair. I mean, I haven't had a briefing on this for a little while. So whether or not each element is yet done is a debatable point. I can't actually answer that question.
Okay. You might be able to help me with something else. In your statement, you've referred to as well, I think, perhaps not in this statement, but in the Victorian Royal Commission statement,
Yep.
made a reference to a risk matrix, which is CRL 0.668.001.0006, which sort of identifies, it correlates to that table we were looking at earlier before the break.
Yeah.
In terms of the areas.
Sorry, can you get someone to show it to me, Mr. Futrell?
Sorry.
Can't see.
It doesn't seem to have made its way onto the screen yet. This is the table, but what I want to take you to is the risk map, which is on pinpoint 0008.
Yeah, the coloured one. Yeah, there it is.
Yes, so it's not this one.
This is the theoretical one. This isn't a populated one.
That's
yeah,
right. That's right.
Yeah, there is one that's populated. Yeah.
You in your statement you identify an example where it's actually populated, but I just want to just get the visual right to start with.
Sure.
So the critical risks are in red, and there's an indication that those risks that are critical, there'll be oversight by the RMC or the board. I take that to mean the board of Crown Resorts.
Correct. But what I said in evidence to Commissioner Finkelstein about this was, and this is a kind of fairly standardised risk map that you see in a lot of places. What I said was, in practice, the Crown Resorts board actually has been concerned with things that are below that critical, that red colour, into most certainly the orange colour. And if you go to the level of risk on, for example, a property by property basis, what you would expect is that you would see things located on a property by property basis that further shifted to the right. Does that make sense? As opposed to what you'd see for the group, because you expect issues to be dealt with on a property by property basis. What gets escalated to the group would by definition be slightly more extreme. I probably didn't explain that very well, did I?
I think I understand. So, and you've actually answered another question, which was this risk map that we're looking at here, unpopulated. There's an expectation there would be a similar document prepared for each property.
I would think so, absolutely.
All right, and
I reckon Mr. Carter will expect it too, and I will expect it as the chair of Crown Sydney.
All right, and so for the individual properties, the areas that are red may be red for the individual property, but amber or orange for the group. That's pretty said, as I take it.
That's exactly right. Because if you think about it, what you want your subsidiary board to be doing is focusing on a greater level of property relevant detail at the resorts level, you want to know if it's material to the group. What's material to Burswood, for example, wouldn't necessarily make it material for the whole group. It might. It depends on what the issue is. So if you take AML, if it's red down at the property group in terms of problems, my bet is it's going to be red up at the resorts board level. But I think it's a question of which particular domain we're talking about.
And just in terms of what is your understanding? What does oversight mean in this context, where it refers to oversight by the RMC board? What falls into that conception?
So it might come down to challenge an inquiry and then satisfaction that management has done what they need to do. That could be everything from taking action to reporting to, I don't know, whatever. It may also be the board basically saying that they aren't comfortable with management's actions in terms of whatever the issue might be. So, I mean, oversight's a pretty broad category. I mean, if you think about it, we talked earlier on today about some of the actions the board has had to take earlier this year, which have kind of strayed into more action, less, supervision. It depends on the issue.
Okay, now, can I take you to an example? I think a little earlier, you mentioned in passing to one of the earlier questions I had before the break, there was an element when we were discussing risk appetite. You said there was an element of judgment involved in some areas. Not everything could be measured by a metric.
Yep.
If I
measured by a metric, I think that was the tautology, Mr. Futrell.
Perhaps. So if I take you to CRW.701.006.3392, which is an agenda for the RMC meeting in August this year,
yeah,
and navigate to point 3427. Have we got a problem with this?
Again, this has material that might involve disclosure of particular methods that...
All right, limit it to the in-room screen,
All right.
please.
Sorry, just before we go to that screen, could we just perhaps go to point 3425 first? And you mentioned...
yeah.
So this is a populated version of the risk map for the
Yep.
group. And you can see it explained, there's references in there to what risks fall into which boxes.
Yeah.
Okay. The next page, which is 3426, which is a live example of the key risk indicators that we were dealing with earlier in the day.
Yep. Yep.
And the next page is an update to material risks.
Yep.
And here's a much more narrative and description of various risks that fall underneath each of the major headings of risk areas.
Yes.
Is this what you mean when you're describing an element of judgment by the management, in terms of what they put into this part of the report?
Yes and no. So because we still have work to do on the triggers, which I talked about earlier, what I expect to see is that some of these elements will actually turn into measurable indicators. But for example, just looking at this one, here we go, maintenance of productive relationship with key stakeholders, which includes regulators. I'm not entirely convinced that's amenable to a metric. It's red, amber or green. How am I going to measure that? So that's a conversation we haven't had yet, but I do think that some of these things are not sort of reducible, if that makes sense.
All right, well, just in terms of escalation, if for instance there's a risk that is not specifically recognised in some risk register or hasn't previously identified, would you expect it to be addressed in this risk report in some fashion by the relevant or brought to your attention through this process by the relevant manager?
Well, mostly is the answer yes. Sometimes no. Sometimes to do with when this was compiled, what the issue is. What I do find is, and what management have certainly been being encouraged to do, is to make sure, because sometimes the documents take time to catch up, if that makes sense, but to talk to issues, to bring business to the risk committee on a contemporaneous basis. So you're not lagged, if that makes sense. By and large, they should be in here, but I wouldn't say my expectation is it's always 100% complete.
So there's an expectation there that let's call it ad hoc items will be reported to you directly as the chair?
Sometimes, yes. And in fact, I've had that happen where there's been a particular issue and I've made it absolutely clear I want to know. And so I will get, sometimes people will ring me and say, look, we don't have a meeting for another whatever, but you need to know X because I've expressed a particular interest. And that then leads to the inquiry about what's being done, et cetera, et cetera. It depends on the circumstance.
And how is that message communicated to the Crown Resorts Group as a whole?
So if you think about it, there's a kind of parallel here. If you look at the picture, which was on page 5 of my statement to this inquiry, I've got the ERCCs. I think we've talked about that a little bit. If you think about the ERCCs, they're not only looking at the sort of metrics and reporting, they're looking at incidents, they're looking at all sorts of things. And we talked a bit before about culture. So one of the challenges is that people really are in no doubt that all the incentives should drive them to, and governance is such that you want to be told. Now, those structures where you should be drawing up from the individual business into, and remembering that they have, including the chief risk officer on each of those committees in each property, they should be another source of hearing, if I can put it that way, that there might be an issue. So you end up with several lines. This isn't just the kind of one communication pipe. There's several ways that this information is going to reach you. That should be the way that this happens, that you have a very clear message across the whole business, the speak up issue. And again, if you go to the Deloitte report, it rightly makes the observation that you can tell people that they should speak up. But if there are barriers to them doing that, well, it leads to a behaviour where they may censor or they may not bring things forward. So this is my point about the cultural component to this. So everything drives you to an environment where things are properly identified and then properly escalated.
Sorry, Mr. Futrell. In that answer, early in that answer, you were talking about the several ways in which information gets to you. Who was the you had?
Well, exactly, Commissioner. So if you're the board of Burswood, so you're the chairman of Burswood, in time, Mr. Carter, you want to be confident that if there is something going on that hasn't, for whatever reason, appeared in a metric or a dashboard or something else, if there's something of concern, that push comes to shove, someone will tell you.
The you is Burswood Limited in our context.
In the first that's right. In the first instance, that is exactly right.
Thank you.
Now, in the extreme, if you haven't gotten traction at Burswood Limited, I want it to be completely clear, and people have actually rung me now because I've made it clear if all else fails, ring me, and they do.
Thank you.
All right, you've actually got ahead of me, Ms. Holton. I was going to take you to this diagram in your statement and ask you some questions about it, and I think you might have covered a bit of what I had to ask you. Mm-hmm. So you made reference to page 5. You're talking about the figure 1 in your
I am. Yeah, thank you. I am.
And I am interested to understand the role that ERCC plays or is intended to play in this process.
Yeah.
So you see, focusing on Crown Perth, the Crown Perth box, you have the ERCC and the Burswood board.
Yes.
Now, do I understand from the answer to my question and the question of Commissioner Owen that there's an expectation that the ERCC will identify risks of the, let's call them the ad hoc nature, and bring them to the attention of the Burswood Board directly for that board to deal with them to the extent it can?
Well, not only that, Mr. Futrell, because you've got the connection through the Chief Risk Officer to the group, you expect if there's a systemic problem, not only for it to be identified as a problem peculiar or particular, in this instance as seen by the management at Burswood, but if the Chief Risk Officer says, oh, that's interesting, I wonder if that problem is potentially occurring somewhere else, then you get the opportunity to look at your systems to the extent that you've adopted these systems, which we've already had that discussion about, then you can actually look to see where there is a problem somewhere else. So I mean, I wouldn't expect the completely undigested contents of the ERCC to be dumped on the Burswood Board, right? What I would expect is a considered level of reporting to the Burswood Board about, given that, the coloured diagram that we had before, if there's a series of risks there which are that the Burswood Board have said or are indicated by the hierarchy are matters for the Burswood Board, not matters that have been delegated to management to deal with. What you expect is those things to come forward to the Burswood Board.
Okay, and then what about? I mean, there's obviously a common link in this framework is the Chief Risk Officer who participates in the ERCC meetings, may or may not participate in the Burswood Limited meetings, but participates in the RMC meetings. So to the extent that it's in the red zone for the Crown Resorts Group as a whole, is it your expectation then it would be reported both through the ERCC to the Burswood Limited Board and to the RMC through the Chief Risk Officer?
Yes, that's correct. And noting that the intended chairman of Burswood is also a member of the CRL Risk Committee.
All right. Now, just in terms of the demarcation in terms of responsibility for, in quotes, managing that risk,
mm-hmm.
if it's of the sufficient critical nature, it will end up being brought to the attention of both the RMC and perhaps also the Crown Resorts Limited Board
mm-hmm.
and the Burswood Limited Board.
Mm-hmm.
Who takes responsibility for addressing the risk in question?
Well, I would say it depends on the nature of the risk. If the risk is material for the whole group, you would expect both the Perth, the Burswood Board, Burswood Management, together with whomever is appropriate at the group level to work on that issue together. If the risk has eventuated from the kind of systemic problem that I suggested was one possibility, so if there's a systems problem, and if it needs a systems fix, well, the experience of the Burswood management in whatever that problem is would inform the fixing of whatever is the system or technical problem. So I think it depends on the nature of the issue that's raised.
Right, so just so I'm clear on this, the common link, if you like, for reporting is through the Chief Risk Officer. Is that the gist of it?
Well, no. I mean, that's just one person, but we've talked already about the metrics. So those ideally will be basically generated systematically. So you're not relying on one person. I mean, what you want here are systems that do not rely on only one person, because there is of itself a material risk. What you want are to ensure that the systems themselves will generate the material that will come to Burswood, will come to Crown Resorts, will come to Melbourne, will come to Sydney. And what you want, though, is the eyes of someone who also knows what's going on elsewhere in that discussion. So someone who's more experienced about the management of risk more broadly. But you can't, what you don't want, I think the best way to describe this, Mr. Futrell, is you do not want a single point of failure in these systems. And that's always one of the challenges with designing these systems. As soon as you have one person, you can have a single point of failure.
All right. Now, where do you see the ERCC falling into the 3 lines of defence model you described earlier? Where does it sit in that model?
So the 3 lines of defence, I mean, what you've got is your risk function, and the people in AML who've got the second line responsibility. I mean, you could regard it as being partly first line, but it's probably more second line than first line in truth. It's a bit of both, more second line, I would say.
And this, obviously, you're familiar with the structure in Melbourne. It's slightly different in that there's a separate audit committee for Melbourne.
Yes.
Do you have a view at all about whether the composition of the ERCC should include a director, as I say, an independent director of Burswood Limited as one of its members?
I'm not convinced about that. I mean, on the grounds of, we've had this problem elsewhere in the business where you have directors performing roles that might be management. So my expectation would not be that there'd be a director on the ERCC.
What about bringing into existence a separate committee that deals with risk and/or audit in Perth?
Audit. Look, I would think that's highly likely for good governance purposes, as I expect there will probably be one in Sydney as well, I might add. That's not a decision that's taken, that's just my leaning, to be clear.
Right, thank you. Now, this might require a bit of juggling because this is an area where I think there's been an update from your Victorian Royal Commission statement. And when I say juggling, I mean juggling of statements. Yeah. So, in the statement to this commission, at paragraph 33, you set out the members of the risk management team and their locations.
Yes.
And in your previous statement, at paragraphs 110 to 118,
Yeah.
you were
Yeah,
describing
this has moved on a fair old bit, yeah.
where things had got to at that point in time. You were looking to fill some roles.
That's right.
And it's probably best if it would seem that some of them have been filled, but if I could just, there's a figure 9 on page pinpoint 0168 of the previous statement. We need to blow that up because again it's hard to read.
Figure 9 or figure 8?
Probably doesn't matter which, but this is as I understand it, probably it's almost impossible to read, I'm afraid. It appears that if we start with the first red box, to be recruited, Group General Manager, Risk.
Yes, my understanding is that has been recruited, but please don't ask me to tell you the person's name.
Right. Would it be Stacey Conlon, potentially?
Sounds right, but please...
And there's a position out to the right of that, Jason O'Connor's in it.
He's left the business.
Okay. Do you know if that role's been filled?
No. No, it has not been filled and it won't be filled. That was, I think you understand the history of Mr. O'Connor and, yeah.
Right. Now, there's another to be recruited, Risk Advisor Perth.
Yes, and you've got 2 roles listed in my subsequent statement. I understand that one of those positions, the one at G, is that position, but to be fair, I haven't tested that for a little while, so that's my belief.
I'm just trying to see where now there does appear to have been. What about the two we recruited from Melbourne?
Yeah, I think that's the person at C.
Right, that's what I thought. Okay, thank you for that.
Yeah.
So
And then because these things are moving, Mr. Futrell, then we've also got the assistance, I think I mentioned to you earlier, in terms of the further uplift that we're doing at the moment from someone who is with us temporarily, who's doing other work on some of this uplift second line, which some of the stuff we talked about earlier today. So there's another person which is not on this list at the moment as well.
all right, now as far as you're concerned as the chair of the risk management committee, do you consider that the risk management function has adequate human resources for Crown Resorts Limited?
Look, at the moment, what I'd say to you, Mr. Futrell, because we're doing the work at the moment, the further development work on the second line, is I suspect we will probably need a few more, but I want to see that work properly built out before I come to a conclusion. I was actually talking with some of the management about this issue, like literally over the last few days. So at the end of the day, we will have the number of people we need to do the work properly. So what I'd say to you is we're doing more of this work literally at the moment, and I think I indicated that I'm hoping some of it will come to the Risk Management Committee on the 17th of November. That may or may not come with an estimate of resourcing that might additionally be required, but this will be what it will be. We need the right resources to do the job properly. So I suspect the answer to that is we will need more, but as yet I don't have a firm handle on what that looks like.
And does that apply specifically to the Perth Casino as well?
Yeah, absolutely. I mean, this is the whole point about the second line, right? So we need to make sure that we have adequate resources to undertake the tasks to actually deliver and implement the framework in a way that is effective. And we need each of our properties, each of them have a need to make sure that that's done appropriately and thoroughly. And that will be the intention.
Have you been made aware of any views that Kroll might have expressed about the adequacy of resourcing?
No, I haven't. But as I said, that's my starting position on this. I'll be surprised if they think we need less.
Okay, can we go back, if I may, just to this topic of escalation?
Yes.
And again, this is something you dealt with in your statement to the Victorian Royal Commission. I think I've taken some of them. You went on at some length in paragraphs 48 through to 70, I think it is, where you were asked some questions in that commission about the changes to the risk management framework over a period of time and
Yes.
and so on.
Yes.
You may have already in part answers to some of these questions, Ms. Holton, but if I could take you to paragraph 50 of your statement there.
That the Victorian statement?
Yes.
Got it, yep.
And
Thank you.
you've said there greater attention to risk issues at the board level and greater engagement in significant risk issues have been evident. Is that a shorthand description of a lot of what we've been covering today?
Yeah, when I joined, so midway through 2018, and there'd been the very scarring experience, obviously, of China, and Ms. Seegers had been recruited before I arrived, and she'd already started work on the risk framework, et cetera, et cetera. And I was a member of the risk committee. I wasn't the chair of the risk committee. Essentially, there had been, as I understand it, I mean, I only discovered this later, I might add, that there had been quite limited meetings of the risk committee prior to those circumstances. And the risk committee had been, when I joined, running at about 4 meetings a year. That certainly wasn't, to my mind, adequate. And certainly once I took over as chair of the risk committee, we increased the number of meetings to 6 and ad hoc as needed. And there was not enough time given in each of those meetings to the kinds of detailed discussion that you would properly want to see, particularly when you're actually developing your frameworks and looking to see how they might be implemented. So there's been a lot more attention to this issue, and that has not only just been in the committee, but it's filtered up to the board as well.
Okay, can I draw attention to paragraph 58 there?
Yes.
That's quite a compressed paragraph. Is that alluding to what emerged during the Bergen inquiry?
Yes, I think that would be probably one way to describe it, as I think has been probably pretty well covered, notwithstanding the fact that you may have had some understanding of risk in parts of the business. And obviously I wasn't there. I know what I know from what I've read, but there were bits of the business that were kind of off the reservation on risk, and the issue about what the actual risk appetite was clearly not understood by everybody.
And does the same comment apply to 62? Is that alluding to what was revealed during the course of the Bergen inquiry?
Absolutely.
With respect to the conclusions many of the conclusions of the Bergen inquiry, as you probably are aware, the recitals to our terms of reference here have summarised them, and there are 3 areas of primary focus. Obviously, there is...
Mr. Future, would you just indulge me for a minute? The room that I'm in, the sun is coming straight in on me, and all I can see is a reflection of myself, and I'm about to have it in my eyes. Would you indulge me with 30 seconds to let a blind down?
Oh, certainly.
2 seconds, sorry.
Don't be blinded.
No, exactly. Apologies. That's, for the moment, that's better. Anyway, I won't bore you with the technical detail of a Venetian blind, which I've struggled to remember how to use. But anyway, we're back. I'm sorry.
Okay, so if I might just put it to you this way, would you accept that the risk of detention of China-based staff was a risk that should have been escalated to the Crown Resorts Limited Board?
Well, I think yes is the answer to that question simply.
And the risk of entering into or continuing commercial relationships with junket operators who had links to triads or organised crime groups was also a risk that should have been escalated to the Crown Resorts Limited Board?
Yes.
And do I take it that you would also accept the risk of facilitating money laundering through Riverbank Investments and South Bank Investments bank accounts was a risk that should have been escalated to the Crown Resorts Limited Board?
Yeah, absolutely. And if I can make one observation about that, I'm not sure that anybody, but certainly the majority of people did not know that Riverbank or South Bank even existed.
All right. Now, those risks that I've just been through, they're not risks that, when they materialised, members of the Crown Resorts management team would have, or they would not have been specifically identified in a risk register.
No, sorry, someone else is coming to fiddle with the blind, Mr. Future, which is why I'm distracted. I'm so sorry. We have a much taller person who is much more able to tackle this. That'll do. That's fine. Thank you. That's fine. Thanks.
Thank you.
That was someone leaping to my defence. So I apologise. Can we just go back to the start of that thought?
Yes, I was pointing out or asking you that those were not, they're of the ad hoc nature of risks, are they not?
No, they're not, you know. What that actually is to my mind, Mr. Futrell, is that is an absolute structural failure. I mean, that was a significant piece of the business that actually was not utilising to the extent that they had one. And as I've said to you, I wasn't there. I'm not fully appraised of everything that they had vis-a-vis their risk frameworks. I mean, this was a number of years before I joined, but that is not an ad hoc issue. That is a structural problem.
And are you referencing there the VIP international part of the business?
Correct.
All right. Now, you might recall a little earlier in the day I asked you about the statement you gave to the Bergen inquiry, and I appreciate you may not have had time to re-familiarise yourself with it.
Mm-hmm.
If I just ask you to be shown it. Obviously, the focus of that inquiry was a little different to this commission, Ms. Holt,
Yes.
but there
Yes.
are aspects of it that overlap.
Yes, I understand that.
And I just want to take you to a couple of paragraphs and before I ask you a question. At paragraph 24, the first sentence refers to, and you might recall you were asked some questions about the advertisement that was published following the media reports,
Mm-hmm.
and refers to a meeting on 4 August 2019
Mm-hmm.
of a subcommittee, and then a brand committee was formed at that meeting.
Yeah, a committee that got known as Brand for whatever reason, yes.
Yes, and then if we could take you to paragraphs 34 and following. Now, you might need to reread these.
Yep.
These were questions around what you knew or became aware of at the time concerning, amongst other things, Riverbank investments and South Bank investments.
Were they? Okay, I'll take your word for that because I don't have the original questions that were put and to which this was responsive.
Sorry, so the crux of it is at paragraph 47.
Yeah, but that's a separate section. And the fact there's a separate heading there, this is my point. I mean, I don't remember the structure of the questions.
Well, can I just...
But they're related, Mr. Futrell, so please ask whatever the question is and we'll see where it goes.
Is paragraph 47 correct?
Absolutely. Absolutely. I've never heard of them. And neither had most of the board. I can't tell you exactly whether any of them had. You'd have to go back to evidence because I do not know. And as I said, I haven't reviewed this because it wasn't drawn to my attention. But that is absolutely correct. I had no understanding of the existence of either of these accounts.
So I just want to ask you if I could show you CRL.563.002.4035.
Mm-hmm. Which is what, Mr. Futrell?
It should materialise on your screen. It's a memo from Mr. Preston to Mr. Johnson and Mr. Carr of
Right.
August. And I don't know, you may have seen it at the time, you may not have. I just want to know.
Well, I don't remember this. In fact, when you say at the time, which time are we talking?
August 2019 or thereabouts.
No, definitely not. In fact, I don't think I've ever seen this, but anyway, please keep going.
No, the reason I'm taking you to it is it in effect is of a similar vein to what you've described in paragraph 47. So I was going to ask you if that was the source of your information. If not, then that's fine.
So as in source of information about Riverbank and South Bank?
Yes, and whether they were effectively within the same regime as other bank accounts.
No, this is my point, Mr. Futrell. Until there was a media report, and this is what my statement says about these accounts, I had never heard of them. So I was not informed of the existence of these accounts by anybody in management or indeed a member of the board, which we now see from this, at least one member of the board was aware of the existence of these accounts.
Right. So when you became aware of them through the media, is that right?
Correct.
And in these meetings that were held in sort of middle of 2019, were managers present at those meetings?
Absolutely.
And were questions asked of them about the existence of the accounts?
Well, the meetings that occurred in 2000 and so this, I can't tell you because I haven't refreshed my memory. I'm sorry, Mr. Futrell, about when I became aware, but it was when the media first reported the existence of these accounts. So when it became clear that, so if you think about it, what we've got here are a series of inquiries being made about a number of these allegations, including in respect of AML, those issues, and including in respect of the work that was being done by others to examine those matters, including initialism, I might add. These accounts were never referred to until such time as their existence became a matter of comment in the media.
And at that time then, were there meetings that you can recall holding with members of the management of Crown Resorts?
Well, again, I would have to refresh my memory, Mr. Futrell, on exactly when that media reporting was. But certainly after it became clear that there were accounts, including that had not been considered by initialism as part of their report to the Risk Management Committee and to the board about the reporting program, the transaction reporting program. So these accounts were not included, they were missed.
Can I ask you this? After the media reporting, were there meetings at which members of the management of Crown Resorts confirmed the existence of Riverbank Investments as a company?
I don't recall whether they were confirmed as a company. I think that may be true, but I can't be absolutely certain. But the existence of these accounts, after it became clear in the media, yes, it was confirmed. And indeed, there were a number of conversations about what actually, and this then became a matter of comment and some notoriety about the opening and closing of accounts due to AML concerns, which you would be familiar with, I've no doubt. None of that had been reported to the board. Well, certainly in the time I was there, and I believe a number of others had the same view about their absence of knowledge.
Was, to your knowledge, there any interrogation of the or questioning of the management at that time about the purpose of the accounts?
I think there was an explanation given as to the purpose of the accounts. They had both been closed, as you would know. And in fact, I remember having a conversation with Mr. Barton in relation to what was happening in terms of examining these accounts. Ultimately, I personally asked to see the statements of a couple of these accounts to satisfy myself whether it was completely evident on those statements, and it was, that there was evidence of structuring. But quite when, that conversation with Mr. Barton, I think was probably in mid to late 2020.
I'm trying to ask you to cast your mind back to when the media reports first were aired in the middle of 2019, whether at that time at the board level there was any questioning of the management about why there was an account in the name of Riverbank Investments, for instance.
I think the question about what was the meaning of the account, as in why they had those names, there was a discussion about that, and the explanation given was because of people wanting privacy in relation to their gambling. What the inquiry otherwise was in respect of those AML issues.
And were you satisfied at that time by that explanation that privacy was enough to operate the Riverbank accounts?
Well, there were a number of people, yes and no. There were a number of people who had extensive experience in the industry who said this was relatively common practice. My concern was actually about whether they had been properly scrutinised as part of the program in respect of AML, CTF, and representations that were being made about the completeness of that program.
All right, can I take you to the Risk Management Committee agenda for 4 December 2019, which is CRW .507.004.5663. And scroll to pinpoint 5690. Which is the risk reporting. And then on the following page at 5691, there's an executive summary.
Yep.
Just draw your attention to the second bullet point page. Do you recall whether there was any discussion at the RMC meeting about the decision of the CBA to close the account?
I don't, Mr. Futrell, I'd have to go back to the minutes and refresh my memory. But remembering, I mean, my suspicion is the answer to that question is yes, because at this particular point, there was, it is fair to say, a rather large storm engulfing the place, and the issue about how a number of these matters were and had been dealt with was a matter of some interest and contention. But the nature of any discussion, I'd have to refresh my memory.
All right, if I take you to CRW .507.004.5742 and scroll to this, the whole entry begins at the bottom of .5744 and over the page, the top of .5745. And just read it if you don't mind, and just if it refreshes your memory, that would be, you might be able to elaborate a little on what transpired at the meeting.
Yeah, okay, can you go to the next page? Yep. Yep. Yeah, thank you. And I think the point about this, so my memory of this was that the question of this being a patron accounts was not entirely clear at this point. As I said, this was a time of some considerable confusion. And the question about what was happening with our reputation, AML in particular, was important.
I'd like, if you can, if you're able to remember what was said at that meeting that led you to the view that appears to be recorded here, that the closure indicated a change in the perception of the gaming industry and the company.
Look, I will struggle to remember this. I'm sorry, Mr. Futrell. My remark, I guess what I think happened, but I would have to think about it some more. But my memory is this whole question about the frameworks we were using, whether or not this was satisfactory to others, and the perception of their satisfaction with these arrangements was a concern. And you'll see that the suggestion was actually that this should go into the company's risk profile. Now, this is before, can I say, I'm pretty confident we understood that these were not being considered as part of, the reporting framework.
Are you able to remember or assist us to understand what that reference actually is to incorporating into the company risk profile? Is it a reference to a change in perception the gaming industry, or was it something closer to the reason for the closure of the accounts?
I don't recall. I'm sorry.
It's okay. Do you recall whether there was any questioning of the management present at the meeting about the reasons for the closure of the CBA account?
I would have to think about that some more, Mr. Futrell. I'm sorry, it's quite a while ago and I haven't turned my mind to this. My expectation is the answer to that question is yes, but I really would have to think about it some more.
I think you said a little earlier that you brought a sceptical mind to the role as a director.
That's correct. And there was an awful lot going on here. This is after there has been, all this controversy and the question, and in fact, putting things in the company's risk profile and tidying these things up was very much a focus. But I would have to think there was a lot going on. I would have to think about who was asked what. There are undoubtedly, these meetings were not absent questioning, but I would have to think about who was asked and what they were asked.
Okay, I'm just whether you can cast your mind back and whether in your mind you began to have any seeds of doubt about the information you'd received earlier in the year concerning
Absolutely. Absolutely.
the media allegations.
Absolutely.
Okay, and so what did you do about that at the time?
Well, there were a number of things. I started asking for additional assurance on things, additional scrutiny from outside. I asked on multiple occasions for people to, and remembering that you are entitled to rely on the assurances you are given, I asked on many occasions, and in fact there are a number of instances in minutes of meetings where it's explicit that I have asked in respect of additional assurances on matters. It's actually one of the reasons, Mr. Futrell, that when we got to the point of getting agreement at the board that there would be an AML officer, AML compliance officer recruited, that I inserted myself in the recruitment of that person.
All right. I want to turn to, in a similar theme in terms of escalation of risk, but to a different topic. You might recall that during your examination in the Victorian Royal Commission, you were asked some questions about your knowledge concerning, I'm going to call it the bonus jackpot issue. You'll know what I'm talking about, I take.
Yep. Yes.
And the effect of the evidence you gave there was that Mr. Walsh had brought to your attention there was something reflecting badly on culture.
From the past.
From the past. It happened in 2012. It wasn't fulsomely disclosed at that time, but it had been cleared up in 2018. Well, I'm paraphrasing your evidence, but it was along those lines.
That's right.
I take it you're aware that Commissioner Finkelstein had made a request for information from Crown Melbourne in the early part of March 2000 of this year?
There were many, many requests, Mr. Futrell. I didn't know about each one individually, but the aggregate of them I was aware of, but not each individual request.
In the course of your evidence in the Victorian Royal Commission, you made reference to expression, bring out your dead context, or worse, that effect. Do you recall there being a request to provide essentially information to the Commission about any breaches there may have been of the Act or the management agreement in Victoria?
Yes, that's right.
Now, do you recall attending a risk management committee meeting in March, late March this year?
There was one in late March, I believe.
Is it your expectation that if any of the managers present at that meeting was aware of the risk that Crown Melbourne may have underpaid casino tax in Victoria, that risk would have been brought to your attention at that meeting?
Well, it would have been my expectation. It would also been the expectation of my colleagues that we would be aware that there was a material risk, yes.
And as I understand the evidence you gave in the Victorian Royal Commission, you did not become aware of that risk until after effectively evidence was given, I think, in June 2021.
In terms of the materiality, that's correct. And the issue, and I think the question of the certainty of the risk, whether there was any contention. So it was presented to us as being an historical matter. And then there was the issue of material that was not provided to the Finkelstein report, which was largely a matter of oversight and error, is my belief. And there is still, I think, some contention about, and there was advice sought about whether in fact there was an underpayment. And I think there is still some debate about a number of items.
Yeah, but the question really is directed to the question of whether the risk, that you became aware of the risk of underpayment of casino tax in that period.
I don't think there was an awareness of a material risk of underpayment.
All right. So were you aware of any risk of underpayment?
Any risk of underpayment? I think, well, I'm not sure, to be honest with you. I think there was some suggestion that there was contention about the definition in a number of areas, but not that there was potential material risk. But I'd have to go back and look at the timeline to refresh my memory. I mean, the problem, Mr. Futrell, has been so much going on that the timeline does tend to get a little bit blurred.
I appreciate that, Ms. Holden. I'm trying to ask you to cast your mind back to the Risk Management Committee meeting in March this year.
Yeah, and I was absent looking at the papers and the minutes. I will struggle to tell you in precise detail. March is a long time ago in the history of what's going on in this company, so I would need to refresh my memory.
All right. Are you leaving us? Are you able to recall whether at that meeting any manager present raised with you, as the chair of the Risk Management Committee, a risk of potential underpayment of casino tax?
So what I would have to refresh my memory of, Mr. Futrell, is when I had the conversation with Mr. Walsh versus when we had that Risk Management Committee. My instant reaction to you is I do not believe I was alerted to a material risk in relation to underpayment, but my memory could be faulty. So I don't want to give you that answer categorically because I have not refreshed my memory about the sequence of events and the particular. There were so many meetings, Mr. Futrell, and I think you understand that there are almost, it seems sometimes like daily meetings of Crown committees. So I get them, I can easily get them confused, and certainly one in March, I would need to refresh my memory.
All right. It would be of concern, would it not, if a senior manager who knew of the potential risk of underpayment of casino tax had not brought it to your attention at that, and he was present at that meeting, would it not?
Yes, and I think that was the essence of the evidence given to Commissioner Finkelstein.
And would it not suggest to you that the message, whatever the message about escalation of material risk, was not getting through to at least some management?
Well, I think there's been a lot of discussion of this issue, if I could say, and I would simply point out that this manager has left the business.
You're speaking now, Mr. Walsh.
I am.
Have you asked Mr. McGregor if he was aware of the potential underpayment of casino tax?
No, I don't believe I have. It's been discussed in his presence. Have I explicitly put that question to him? I'm not sure that I have.
What about Ms. Seegers, if you asked her if she was aware of the potential underpayment of casino tax?
I don't know why I have this understanding. I have an understanding that she was not aware, but I don't know where I have that understanding from. It may well have been from a conversation. Whether it was a question put by me is a separate question.
All right. can I ask this of you? If you became aware that a senior manager had not brought it to your attention and ought to have, what would be the consequences of that failing?
Well, it would depend on the context, to be honest with you. What I would say to you is the following. Some of the cultural issues in the business, and remembering, if we are talking March here, that this is some 2 or 3 weeks after the business has had enormous change. The large majority of the board exited. Significant numbers of senior managers were either on their way out or had left. But I think it takes a while for the message to actually, one, be delivered effectively to all people, and secondly, probably to be heard. So I would not, in the first instance, say that somebody who on inquiry or with an opportunity to say where they didn't in, say, March or April, I would not want to give them an appropriate opportunity to demonstrate that they have the best interests of the company at heart. I mean, I think the regime, Mr. Futrell, that was in place was there for a very long time. And I do think what we're seeing with the new management is the opportunity for some people to demonstrate that they have heard and that they are working consistent with the ethos, the spirit, and the letter of the law in these areas. So I think it would depend on the context, and it would depend on the seniority, and I think it would depend very much on whether or not I have been convinced that the person has understood that there's a new broom and that they are behaving in a way that is completely consistent with that.
Well, given, I think as you've acknowledged, the previous regime was in place for a long time, do you have confidence that managers that participated in that former regime will appropriately escalate risk in the future?
I actually believe, and the actions that I have seen a number of those managers take, Mr. Futrell, and what I have seen so far, I have not seen a red flag. But I do think a number of people will receive a higher level of scrutiny for those reasons. Can I make one additional point though, Mr. Futrell? One of the questions I got asked by investors in the very, very many conversations I had with investors in the run-in to the annual general meeting was whether we had sufficient corporate knowledge to run the business. And so I don't think it's either desirable or practical to not give particular people who were not the boss, if I can put it that way, give them an opportunity. And I treat people in the context that we are now very fortunately in. This is not an easy place, Mr. Futrell, let's be clear, but we have what I would describe as clear air. Now, I'm treating people on their merit, and it is not a matter for me in terms of people's employment. That is a matter for Mr. McCann. But the ethics, the expectations are being made very clear, and people need to live by those. And to your point, if people do not, in the regime that we're describing and we're building, if they do not do the right thing, there won't be very much sympathy for them.
Well, thank you, Ms. Holden, for that answer. Can I would like to move to a different topic, if I may, which is something we started the day on, in part, which is the question of harm minimisation.
Yep.
And in the topics, I think I'd like to call these up, please. It's PCRC .0002, .0029, .008. And page 15, or 0.0015. There are two specific, there's more than one question within them, as you can see, but these are two specific topics that were brought to your attention.
Yes.
And you have addressed this in paragraphs 55 to 63 of your statement.
Yep.
But just focusing on the specific questions that or topics that were in the information that went to you, I take it from the answers that you have given, or the explanation you've provided in answer to these questions, that you consider that the Crown Group has obligations and duties to minimise gambling-related harm from the gambling operations at the Perth casino.
Mm-hmm.
We may, at the risk of traversing some ground that was already covered today, but can I just ask you, what do you consider to be the proper nature and extent of the Crown Group's role in minimising gambling-related harm?
Yes, thank you. What I'd say is there's a couple of elements to this, so bear with me if you would. To start with, we do need good evidence-based programs, and that means by definition they will change over time as evidence improves, to identify and then provide appropriate interventions for people who are at risk and indeed who are experiencing gambling-related harm. We don't, however, have an obligation to provide treatment services for those people. We do have an obligation to continue to work on the information and knowledge about how those either actual, realised risks or potential risks may occur. So that includes in respect of data gathering, research, etc. And we do have an obligation to work with what I would describe loosely as the community sector, because they often will understand things about how gambling and gaming related harm, and particularly the role of casinos in that, are manifest that might not be part of our we can't see it ourselves. Do you know what I mean? In terms of the people who attend our premises, we have the responsibility of ensuring, wherever it is practicable to do so, that we provide the interventions in this respect in a way that has the most chance of being efficacious. We have the responsibility to work and to be open to families and others who may come on someone else's behalf to seek assistance. And we have a responsibility at all time to ensure that people who are in any way distressed or showing signs when they're in the facility, that they will actually receive an intervention.
What do you mean by intervention? You mean as in a withdrawal of the ability to be on the premises?
So there's a hierarchy of those things. And again, if we go to that list in the panel's report where it talks about the public health hierarchy, where for some people the interventions will be the provision of information, the provision of external cues, the provision of an environment that enables them to take alternative actions. For some people, it will be the tapping them on the shoulder, having a nice chat, etc. And for talking to them to make sure that they're not distressed, and in some cases suggesting to them it might be time to leave in a nice way. And in other instances, it will be the withdrawal of licence it will be the implementation of the regime where people either voluntarily or not voluntarily are excluded. And it may also be a circumstance where, in terms of their withdrawal of licence, some people, there's a kind of, in the Victorian context, there's a whole regime around how you withdraw for a period. Some people find that too difficult to come out in the first instance, so they voluntarily exclude themselves for a lesser period. So it's essentially a hierarchy, and the hierarchy is relevant to the needs of the individual and the context in which they're in. And all of those things need to be properly implemented with staff who are properly trained to do that work.
All right, so putting to one side intervention then, do you consider the casino operator has any responsibility to restrict or modify the way in which it delivers gambling services?
Depending on the circumstance. So we know that the large majority of people who gamble do so without harm. If there were to be some particular aspect of the recreational part of this that is universally damaging and dangerous, that requires a restriction, well, clearly, and this is my point about evidence, well, clearly you would look at that, yes.
When you refer to evidence, are you having in mind that there will be some form of study undertaken to identify, if you like, what causes there may be that lead to some individuals developing a gambling-related problem?
Well, cause is a big word in any kind of social science research. So let's think about it in this way. We know people with problems with gambling are more likely to gamble using a number of different channels. And they will most likely not use just one channel, they will use multiple channels. So the issue about how you identify those people, how it is you provide supports to them, whether there's anything inherent in the service offering and the particular individual's response to that service offering, all of that is amenable to research, yes. And whether there are interventions, to go back to that word, that can be developed, and there's quite a bit of work going on in this domain, Mr. Futrell. So, for example, whether a message comes down in front of the person in relation to breaks, whether there are other mechanisms that can be used to minimise or to moderate harm or potential harm. All of that is, and this is one of the reasons for having the panel, is to be informed as best as is possible and then to contribute through data collection to that research. And that's one of the reasons why in the increase in resourcing into this area, agreed some many months ago, one of the positions, including in Perth, will be someone who actually has a research remit.
If the outcome of the research indicates that there are modifications that can be made to the way that the gaming services are delivered, is it your expectation that those modifications would be made?
As a general rule, yes, it would depend on how widespread. I mean, if we're talking about one individual who may be negatively affected, then your right response in a broad regulatory context would be to try and exclude the individual and not disadvantage the bulk of people who use something. But if there is something that causes widespread harm, absolutely you'd expect it to be dealt with.
All right. Now, in the context of money, the financial crime area, you would understand from the remediation plan there's a enterprise-wide risk assessment being undertaken.
I do understand that, yes.
Do you see any value or possibility in undertaking a similar kind of exercise with respect to gambling-related harm in the casinos, to say an enterprise-wide harm risk assessment?
Yeah, well, look, I've heard this contention, and I have to say it's a bit of a misapprehension about what an enterprise-wide risk assessment actually is. I mean, an enterprise-wide risk assessment is something where you look at the whole environment in which you're operating and where you think about the risks that they pose to the way your business operates, and then you move to mitigate those risks with your systems, processes, etc., because you're looking at a risk-based approach. I don't think there is a direct parallel with looking at the harms that you might consider in this context. And what I do think you can do is look at the way people use where they gamble, the context in which they gamble. I think you can look at the operation of machines. I think you can look at the physical environment in which they gamble. But I do not think that is the same as an enterprise-wide risk assessment at all. The truth is, this area is it's extremely complicated in terms of human behaviour. It is very complicated to work out what the drivers are. And so, yes, we are doing and we will continue to work very cooperatively in this area. But the notion that one process will give you the answer on this, I would challenge quite vigorously. I'd also say to you that the reason groups such as the Productivity Commission, et cetera, bring in a variety of experts, and this is exactly why we did what we did with our expert panel. We went and found a group of world-leading experts in this domain to look at all of the research and continue to look at the research to give us a view about how best to tackle these issues. But our commitment, Mr. Futrell, is very clear. That this is unbelievably important, and we want to be the best in the world at this. There's no doubt about it. But I don't think there's an easy way to draw a parallel between an enterprise-wide risk assessment and looking at harms in this context.
Right, now just to put it to you bluntly, do you consider that at present the Crown Group, or Crown Perth, or both really, are adequately mitigating the risk of gambling-related harm at the Perth casino?
I haven't been to the Perth casino for some time, and I'm aware that we are recruiting more resources. What I don't know, Mr. Futrell, is whether those resources are in place. I know that there's been a lot more training of the staff on the ground. So when I look at an on-paper analysis of how those resources have been provided, they certainly look, and I also am aware that the centre that is used to talk with people, to offer advice, to refer them to services, is being significantly modified. But I haven't had the opportunity to come and talk with the people on the ground, including the people who are actually working on the gaming floor, to give myself an assurance. Now, I have been able to do that in other parts of the country. I've sat in on training of staff in Sydney, notwithstanding that we're not yet open. I have participated in those processes to give myself an assurance. So what I see on paper with the new arrangements, I believe to be good, and I've talked to Professor Blazinski about this, but I haven't seen this myself, and that will be my intention the first opportunity I get. So I would say to you on paper, I think there's good action being taken. But if I can, sorry, I feel like I'm going on too long, but the other thing I'd say to you is we are looking around the world for the systems, and there are a couple that have been developed, but they're in very early stages, to actually work particularly on EGMs to monitor people's play. So there's still more that can be done. So I don't want to say to you that, oh, it's all fine, and on paper it looks fine, because to my mind there is much more work that needs doing. But are we doing what I think is significantly improved on the paper? Yes, but it does not mean that we're done. All
right, now, Mr. Blackburn, he has primary responsibility at the executive level for gambling-related harm.
Yes.
And obviously his expertise clearly lies in the financial crime area predominantly. Do you have a view, or do you consider it appropriate that Mr. Blackburn has the primary responsibility for this area?
So, as the member, one of the very most senior levels in the company, he has this responsibility together with his AML CTF responsibilities. I actually believe that Mr. Blackburn has a huge energy and commitment to this particular issue, and I do believe that he has the capacity, recognising, and I think this is important, that we are recruiting a more senior person than we had previously in the role. So I believe Mr. Blackburn does have the capacity to oversight this area, but this is in a context where he will be assisted by a specialist. I mean, one of the issues we have, and what I'd encourage you to think about in this respect, Mr. Futrell, is, you know, the higher up you go, the more you can't be an expert on everything. That's why we have colleagues with various skills. It's why we have a risk matrix at the board. And in the most senior levels of management, Mr. Blackburn, I believe, has the energy and the capacity and the systems thinking and approach to undertake this work. But he has to be assisted by people who are clinically expert in doing this work.
Right, thank you, Ms. Holt. Can I ask you some more policy-related questions in this area, just to get your sense, given your background? Do you have a view on the extent to which civil or criminal penalties could or should be imposed on casino operators as a means of encouraging harm minimisation?
Look, you're straying into an area which I do not have policy expertise in. The creation of penalty regimes is not something that I've spent any of my professional career on. My instant reaction is that to criminalise is to take a very large mallet to this issue. I mean, I think there should be accountability, absolutely. But to take a criminal lens to this, I think is probably a little extreme.
All right. Well, if you look in the area of occupational health and safety, for example, there are sanctions imposed of criminal nature in that area for causing harm to workers.
Sure, absolutely. But let's be clear. If you are on a building site and that building site is fundamentally unsafe, you can look to the construction of the building site and say that's a problem. With gambling, you can be gambling not just at Crown, you can be gambling on a whole variety of websites. You can be playing poker with your mates. You can be doing a whole series of other things. And so I think in an environment where you are not the sole controller of the risks that the person faces, I mean, I would draw a parallel with the fact that in most jurisdictions, you're not now liable for workers' compensation during travel to and from work because of the other risks, because you can't control all of those risks. So I would struggle with that parallel.
What about sanctions, for example, for permitting people who have self-excluded to enter and gamble in the casino?
They should look. That's an appropriate concern. I think the question about whether all reasonable steps have been taken, I think there are systems and processes that need to be in place and need to be operating reliably. If they are not, there will occasionally be mistakes, Mr. Futrell, but if there are systematic breaches, yes, I agree with that.
What of sanctions for accepting funds for gambling where the casino operator knows or has reasonable grounds to suspect they are the proceeds of crime?
Well, absolutely. I mean, there shouldn't be any circumstance in which you accept funds where you have any conception that these are the proceeds of crime.
What I'm suggesting to you is there may be a specific sanction associated with that, though.
Yes, I think there should be. I have no problem with that from a policy perspective.
All right, can I return now to a topic we started with, actually, at least you almost immediately went straight to this topic, which is that of culture. And you have, in response to some questions, laid out some views about that in your statement. And I think you said earlier you'd read the Deloitte Culture Review.
Yep.
And what is it that you? I think you said something. It was informative or words that effect.
Very useful, I think, is what I said.
It's very useful. So, what aspects of it do you consider to be useful?
So, Mr. Futrell, when you're embarking on a very necessary program of change, and I have already, I think, covered this, where you're looking to embed, entrench, have part of the warp and the weft of the culture of a place, issues around ways of working, cultural attributes, regulatory compliance, an understanding of what your role is and how you should work with others and what your responsibilities are, both to the people with whom you deal on a day-by-day basis, but also broadly to the community in which you deliver this service. That one of the things that was really evident to a number of us, and particularly, and this was in the risk context, and I might remind you, I'm sure you know this, that this started as a piece in the risk context. It was the early part of the work on this was done by Ms. Seegers, and it's been taken over by Mr. Weston. So understanding the base position in which you find yourself, if you're going to design culture change programs, if you're going to think about how you are able to do this work, you actually have to understand root and branch what the issues are. And so this particular piece of work, and the reason I like the work that Deloitte's done, is it gives you, in each of the attributes, both the opportunities but also the barriers. So if you think about the way the report is structured, in each of those domains, you've got opportunities and you've got barriers. So what is it about what people have said? What is it about how they regard the context that gives the opportunity, as you do this cultural change program, to build on? And then what are the barriers? What is it you have to have dealt with, addressed, removed, whatever it might be, in order to actually make your cultural change effective and make it stick?
All right. Has there been discussion of that report or review at the level of Crown Resorts Board?
Many times.
Okay. And has that resulted in any decisions to implement any proposals for change in connection with the report?
Well, I describe this as happening in layers, if I could. So Mr. Weston has been working on a very detailed cultural change program, which will be very comprehensive, but will also take time. And I think you've got Ms. Arzadon either is giving testimony or has given you some sort of report, and you would know that she gave a report in the context of the Finkelstein Royal Commission. I should say that I've already seen Ms. Arzadon's work in the banking context, and I think what she and I would be completely in agreement on is the fact that you can't affect cultural change quickly. You have to basically, you can get behaviours to change pretty quickly, but you have to have systems and processes and reinforcement over a long period to entrench that. Culture is very sticky. It's a very hard to get your hands on, difficult thing. And so this is why I've talked already about the need to have everything working congruently. So your remuneration policies, your reporting policies, your accountability, etc. So there have been many discussions about that culture report, and Mr. Weston has talked about a number of the elements. Not all of it is yet finalised and developed, and he's obviously been talking with Kroll about those plans and where we're at on them, and that conversation is, I think, going very well. So we've got a way to go yet, Mr. Futrell, but the journey is well and truly commenced.
Okay, can I ask you something in connection with this, it may be in connection with this, I'm not sure. In paragraph 66 of your statement, you have indicated
Yes.
What appears to be indicating a change in purpose and values.
And the message being heard, I think, is the other. Yes. I mean, and this is my point, Sorry, you were probably going to ask a question rather than me start talking. What's the question?
I was going to ask you whether there has been a recent change in the statement of Crown Resorts values or description of them.
Yeah, we have. So we've talked about the purpose. So one of the things that came out of the Deloitte report was the need, and I think this is consistent with Ms. Arzadon's observations as well. We need to have a purpose that connects everything we do, including to the community. That's one of the things which is in that report. And so the restatement of our purpose about exceptional experiences, caring for our community, which is part of that new purpose. And that was well tested with staff. So there was a lot of work done, including through focus groups, etc., on redrafting of that, and then being very particular about the values. So, and the values do go to those issues around, the compliance issues, the way we work, etc., etc. So, and again, recognising that the opportunity to talk with people has been relatively limited in the last couple of months, but the message, which we certainly were endeavouring to communicate from March onwards, and recognising it can take a while when you're trying to communicate with a working body of 20,000 people. One of the things, and I think I talked about this at Finkelstein, one of the things I have a habit of doing when I'm in any of the properties is just kind of wandering around chatting to people. I stay at the property in Melbourne when I'm in Melbourne for other purposes. I've stayed and visited the Burswood property many times over the years, and I've certainly been to visit the Sydney property on many occasions. And the thing I would say to you is that in talking to people, the message, the fact that there is a change in the tone and the message, certainly I've been getting feedback that people have heard that, which I think is important. But to the conversation we had earlier, entrenching that. So, and again, it's exactly the discussion we had earlier. If you've got 20 staff, you can be on their shoulder, you can live, breathe and eat it and be visible. When you've got 20,000, you have to have all the other drivers running in the same direction.
Right, in amongst the documents you have referred to, I think as part of the framework, either I've lost track of which statements in, Ms. Holton. You make reference to something called the Risk and Compliance Culture Framework.
Yes.
And in that, it also makes reference to something called the Enterprise Culture Steering Committee.
Yep.
Is there such a committee that has been formed?
There was an Enterprise Culture Steering Committee at that point. Mr. Weston, since he's taken these things over, I haven't actually asked him. He certainly has a steering committee. I don't know what he's called it.
All right. Do you know who the members of it are?
No, I don't. I'm sorry. That's probably an oversight on my part that I haven't asked him explicitly. But there is a high level of engagement in the management of this issue across the business, but I can't give you the precise names. I apologise. We can get those to you if you like.
Is there a committee of the board of Crown Resorts that if you like, the cultural change piece to the remediation is within the remit of that committee?
Yeah, so it would normally be the people committee. With the departure of Ms. Korsanis, as you would know, she retired at the end of the AGM. What we've agreed is that committee is rolled into the board for the meantime. Dr. Switkowski has indicated that he would like and will chair that committee when he gets his regulatory approvals. So until such time as he joins, those issues will be dealt with by the whole board, and I think that's in recognition of the importance of them.
All right, I want to take you to a comment you made a little earlier about the change takes time, or culture takes time to change a culture. Do you have any sense of the time frame, either based on your previous experience and your knowledge of Crown Resorts, of how long you think it will take to really embed the new culture into the Crown Resorts group?
So what I would say to you as a general rule is I would expect 3 years. And some people would tell you 3 to 5. What I would also say to you is that when you've had, I think, what is euphemistically referred to as a burning platform, you do tend, I think, to get much greater focus. If you can capitalise on that, so in other words, while you've got everyone's attention, I think you can probably be more confident earlier. I do think, again, if I refer to my banking experience, particularly the issues in respect of risk culture in the banking context, we're now several years on from the Royal Commission. We've seen good progress across all of the major banks. I'm not so familiar with the smaller institutions, but I do think you keep working at it. Does that make sense? I don't think you ever take your eye off it, but I think you can be more confident as you get a couple of years in.
All right, there's been obviously been quite a bit of change at the level of director and senior management. Is any part of the remediation plan intending to look at, if you like, those who run the show, the middle management level, and the extent to which cultural change is necessary at that level?
Well, just to start with, I don't care if you're on the door in any of our properties, whether you work in the plant room, whether you're a middle manager, whether you're a senior manager, this program applies to absolutely everybody. And there's no doubt that I think in Finkelstein that they used the rather unattractive language of permafrost. Look, my experience actually is you don't get a thing about permafrost, as in a layer below which you can't penetrate, if what you do is you engage staff right across the organisation. I mean, I've run very big enterprises in my time, and if you have a good process of engagement. Now, a bit like the question you asked me earlier, Mr. Futrell, about people down at those levels, we need to give everyone in this organisation the opportunity to succeed. We need to give them the opportunity to work in a context where there is no ambiguity about what we stand for, how we expect people to operate. We need to make sure that all of the drivers, all of the things which motivate your behaviour are consistent, they're completely congruent. And what I can tell you is I actually very firmly believe that people right down the organisation will respond to that. And I think there's large parts of this organisation, you know, the thing they care about is customer service, and they take huge pride in their work. And I know that that is the case as much at Burswood as it is in Sydney. But we will be very clear about our expectations right through the management levels, right through the organisation. And, you know, there's some things in that Deloitte report, Mr. Futrell, which, you know, you don't want to read about. You don't want to read about bullying. You don't want to read about people who are overly hierarchical. You don't want to read about people who are not encouraging their staff, thinking about their development opportunities. That's not who we want to be, and it's not who we should be. But that process will engage everybody.
Okay, thank you. Can I direct your attention to paragraph 77 of your statement? And you've used some language here that might have some management meaning, but the meaning escapes me.
I'd be very happy to disentangle it for you, Mr. Futrell.
If you don't mind. So there's a reference to the approach that Crown previously adopted to remuneration without a step with normally accepted remuneration practices of a listed entity like Crown. This is not one of the ones I'm worried about. But what are you meaning by that? Out of step?
Out of step. So, and I had to discuss this with our investors. This was the reason we got a second strike at our AGM, because when we were saying goodbye to a significant number of our senior executives, their remuneration arrangements, their contractual arrangements, were not as you would see them elsewhere. And that meant that they were all legally entitled to very significant payouts. That was not something that our investor community were happy about. And as I have said to them, I was not particularly happy about it either, but they were their legal entitlements. And that was because of the way their contracts, most of which were very long standing, had been constructed. And as I said to the AGM, that horse had bolted. That doesn't mean we intend to continue like that.
All right, you might be alluding to this. So what's a value-based gatekeeper provision then?
I know it's terrible language, isn't it? So you're entirely within your rights to go, what on earth does that mean? This is common parlance in this particular world. What it means is quite actually simple. If you do not follow, demonstrate, practice the values that we have said, and you do not have regulatory compliance, you're not doing the job consistent with our regulatory obligations, it doesn't matter what else you do, you will not be eligible for any long-term incentive or any short-term incentive. So when we talk about a gatekeeper, the way they have balanced scorecards and they have different elements which go to whether or not, and they have different weights and values, they go to whether or not you are eligible. So you might have your base salary and then you have the components on top. If you don't show the values and you don't have the compliance demonstrated, well, that means you're not eligible. It doesn't matter whether you have had fantastic financial outcomes. If you haven't got there the right way, you're not eligible. And the other thing that's relevant to this, and again, I draw here from banking a little bit, we claw back if we discover something later. Yeah, so we didn't know it at the time, we paid you, and we discover something later. Well, clawback needs to be a feature of these systems as well.
Okay, and a little easier to understand, but maybe not all the nuances. Mandatory compliance and risk key performance indicators. There's a mandatory aspect to that. What's meant by that phrase?
Well, it's the same essentially. If you do not comply, if you're not part of ensuring that we comply with our regulatory obligations and issues in respect of risk, you will similarly not be eligible. You will have not undertaken your responsibilities. So when I talked before about making sure that all the drivers of behaviour are congruent, so we've got the carrot, Mr. Futrell, this bit's the stick.
Okay. Now, I just want to ask you again some general questions here about the nature of the regulatory relationship or the environment.
Yes.
Now, you're no doubt familiar or heard some of the evidence that this Commission's heard regarding the closeness of certain relationships between Crown staff and the Western Australian regulator. What's your view of the appropriate nature of a relationship between the regulator and the regulated in this casino context?
Professional, respectful, and at not an unreasonable distance, but certainly appropriate to the role, professional and not personal.
And do you have a view about the extent to which communications with the regulator should be transparent, open, candid and frank?
Absolutely. And Mr. Futrell, it's worth remembering, I've been a regulator for a fair amount of my career. At the end of the day, you can't do your job as a regulator unless you've got a good dialogue with the regulated. But similarly, and you have to be able to be frank, but you want the regulated party to be open and transparent with you. It is fundamental to the relationship.
And what steps do you see the Crown Resorts Board taking to ensure that the licensee here, Burswood Nominees, maintains an appropriate relationship with the GWC going forward.
So, and again, I am aware that you, I think, talked to Mr. Carter about this. This is absolutely crucial to us. I should say that I have had a conversation with the Victorian regulator. I've had a conversation with the New South Wales regulator. I wrote to the WA regulator. I have not had an answer. I've had an answer from her office saying she's a bit busy. But one of the key messages I have been delivering is that we need to ensure that the relationship is appropriate from both sides, and that the Crown has and will continue to have a commitment to ensuring that that dialogue is open and robust. And the Crown Resorts Board will be expecting that each of our subsidiaries will not only behave in that way, but that will report to us and be accountable for their behaviour. And that's actually part of the thing that we were just talking about in terms of the remuneration arrangements and how we structure them.
Right, thank you, Ms Holton. I've no further questions.
Thank you, Mr. Futrell. Ms. Holden, we need to give our transcribers a break, so we'll break for 10 minutes. So
Okay.
we'll come back at 5 past the hour.
All right. And Commissioner, is it very unreasonable of me to ask any idea how long we might still be here?
It's not entirely in my hands, Ms. Holden.
I understand that. It's just, okay, it's fair enough. It's an unreasonable question.
I'm not suggesting it's going to take anywhere near this time, but we will be out of here before 8 p.m. your time. And I'm not saying it's going to take all that length of time.
No, thank you. I should have asked, when do you rise? That would have been the better,
We'll-
more appropriate question to raise.
But we will put something of a stop clock on to make sure that we finish. Thank you. We'll come back at 5 past.
All right.
Thank you. Please be seated. Thank you, Ms. Halton. Now, I'll start with council who are not in this room. Are there any applications? No. Are there any applications from the room? No? No.
I've got a couple of questions for you, Ms. Halton. In respect of the Barangaroo Casino, it was developed with approval for gaming by rebate players and members-only premium gaming. With the reduction in the number of overseas gamblers and prohibition on junkets, if the Crown gets the licence for Barangaroo, is there any plan or discussion about broadening its patron base?
No. Not that I'm aware of, Commissioner.
And also, I understand that poker machines weren't to be permitted at Barangaroo except with regulator approval. Is there any...
No, they're not permitted at Barangaroo. There's no suggestion that and frankly, we don't have the space.
Now, prior to the Bergen inquiry, you were aware of the risk of criminal infiltration of casinos by through junket operations?
I wouldn't say through junket operations specifically, but the criminal issue was certainly something that I was cognizant of, yes.
And how did you think that CRL was managing that risk at its Australian casinos?
Well, as I think I've indicated, the AML-CTF responsibility under the legislation actually resided a word, maybe not. It's not resided. Anyway, it was with each of the subsidiaries. The issue of criminal infiltration, there was and is an extensive security function at Crown. I had met with the head of security, in fact, before I agreed to join the board. And I had met with a number of other people in respect of the programs that were operated by the subsidiaries. And certainly the relationship with policing, the interactions with AUSTRAC and a number of others were all part of what was put to me as being the program in those respects.
Now, you've given evidence to the effect that the Crown which exists today is very different and better to the Crown that existed in 2018 when you joined the Crown Board. Would you agree with that?
Wholeheartedly.
Why were you content in 2018 to join and remain on the unreformed Crown Board?
Because it wasn't all evident, Commissioner. I mean, you do your due diligence before you join the board of a company, and if you talked to a number of people, which I did, it did not look to me as being quite what we now understand was the case in the parts of the organisation. It was not evident. And it was certainly represented that the errors, omissions, etc., that occurred in the run-in to 2016, which is when those events occurred, that there had been substantial uplift and mitigation in respect of those risks. Now, it takes you some time when you join to learn actually the detail, and I have to say, I mean, in my experience, it does take you a while when you join a board to actually start to unpick the really detail, and of course, at about the same time, we know that then there was quite some commotion.
So when you said you did your due diligence, but things were not revealed or to you so that you became aware of them, what do you see as the impediment to those things being revealed to you at that time? Well,
you when you do due diligence, Commissioner, you talk to the staff, you talk to other directors, you inquire of others in the broader context. you ask the questions about systems and processes and commitment to AML and all of those other issues, and you don't necessarily see the work detail. And I think, as we now know, some of the detail of what was going on lower down in the organisation wasn't communicated.
And that was a management failure, is that?
I believe so.
On another topic, you said that Crown did not have to provide counselling services to those suffering harm from gaming. Just on that issue, you may not be aware, but the Crown Perth directly contributes funding towards the Problem Gambling Support Services Committee in Western Australia, which then provides funding to gambling or counselling services for people affected by gambling. Do you have any issue with the Perth Casino providing funding in that way?
No, on the contrary, I'm very supportive of it, Commissioner. I think the word I used was treatment. What we I don't think are appropriately a treatment service. We actually do counsel people sometimes, particularly when we're talking with them about exclusion, and it is absolutely appropriate that we make a contribution to those services. And I talked about the need to ensure we are really engaged with the people who provide those services, because they often have knowledge and intelligence about the circumstance of the service we deliver, but also sometimes of patrons, that it's important that we understand.
And do you have any view about whether Crown should be involved in the determination of where that funding goes to? Which particular services are engaged?
No, I don't necessarily. I mean, my preference in these matters is usually to have those things done at arm's length. I mean, you would certainly have a view that the service or services that those funds go to should be highly competent and should be directed to the problem. But in terms of, being the determiner, no, I don't have a view.
Right, thank you. I don't have any other questions.
Thank you, Ms Halton. I have just a few, 2 or 3 questions for you. In an exchange with Mr Futrell, you said that you wouldn't see a director of Burswood Limited being on the ERCC, but that, and you stress this with a personal view, not one that the board had considered, but that you could see a situation where there was a new committee in Perth and probably similarly in Sydney.
Yes.
I take it that you are there referring to a proper committee of the board of Burswood Limited?
Yes, absolutely, an audit and risk committee most like.
And would you see, ideally, a non-executive independent director being on that board committee?
Oh, absolutely. And I do think there is an argument that can be mounted, Commissioner, that you may actually want an independent to chair that committee. I mean, the level of scrutiny that comes, and I have to say, I do chair a financial risk and audit committee at a law firm, as it happens, and I am the independent member of that board, and I chair that committee, and that's for a very particular reason of scrutiny. So I think there is a good argument to be made in that respect.
And I notice in figure 1 in paragraph 24 of your statement, there's no need to bring it up, I'm sure you can recall it, but there are 2 committees of what looks to be 2 committees of the Crown Melbourne Board.
Yes.
An audit committee and a compliance committee.
Correct.
Now, if you were to replicate a similar structure under Burswood Limited, would that not strengthen an argument for an additional non-executive director at Burswood Limited level?
Yes, I think that does make that argument, Commissioner. And I think I've said I'm not averse to the notion that there would be another local director. I think I talked about my experience of, the balance between the directors, and I'm a big supporter of having that level of local involvement. So I agree with you. The thing I'd say to you about committees is they of themselves bring quite a bit of work in terms of, agenda setting and minute taking and all those other things. And whether you need one or two, given the size of the business, would be, I don't have a formed view on that, but I think you would think that through.
And if I can concentrate on the risk area, then
Yes.
it doesn't matter how many committees that you have, but if you did have a committee of the Board of Burswood Limited that was looking at risk issues, how
Yes.
would you see, and I realise that this is not a developed proposal by any means, but how would you see that interacting with the ERCC, or would it replace the ERCC, or how would you see it interacting?
A very important question, Commissioner. So no, it wouldn't replace the ERCC because it's the management process where you bring together the managers to work through the risk issues. But you would see there being a very close relationship between the ERCC, its reporting and its operations, with either the board itself or the committee of the board. So, and again, we're making here, aren't we, the distinction between governance and management, which is one of the reasons I don't think you have a director on the ERCC. We need to be clear about, in the normal course of business, how we keep that line. But yes, the ERCC clearly has a direct line into either and or the board and any of its committees.
Thank you. On a different topic, when you were in an exchange with Mr. Futrell about the risk matrix and the risk management strategy, one of the examples you gave of difficulties was the relationship with governments and regulators. You said, I think, that it was very difficult to measure that as a risk. Now, accepting the difficulty of measurement, nonetheless, when you are looking at the relationship between the regulator and the regulatee,
Yes.
From the point of view of the regulatee, what are the factors that you would take into account in assessing how you're going in managing that risk?
Absolutely. And, as I said, having been a regulator in my time, and now, the boot's on the other foot, so to speak, I mean, the things that I used to, and I think this is still germane, is there a regular exchange of information between the regulator and the regulatee, which is other than standard reporting? So you would have obviously systematised and regular reports, but what you want to see is the regulated raising with the regulator matters of concern and contention, issues of uncertainty. And I think also if the relationship is good, if there are things that are happening in the regulator's environment, giving the regulated, giving the regulator a heads up about what is actually going on, I think is good practice. Now, similarly, the regulator, I think, actually has also an obligation to work constructively with the regulated entity. This is It Takes Two to Tango, Commissioner. And so one of the things I used to find, and I used to know when I was a slightly more junior public servant, and I had a lot of inspectors who were running around a particular sector, I knew when our relationship wasn't very good because I would start to get complaints from the regulated sector about heavy-handed nature of my inspectors, et cetera, and you would look to see whether in fact it was a reasonable complaint, whether we had perhaps some communication issue or absence of training or whatever else. So you would take that on board to assess whether your performance as the regulator was up to standard. And so what I'm, I guess, conscious of, and this is why I talked with Mr. Futrell about, I think, the difficulty in sort of boiling all that down into a bunch of numbers and triggers, because I think so much of that is having your ear to the ground and being aware of what the nature of those interactions are. Now, that is not the same, Commissioner, as some of the behaviours that I think you've taken evidence about.
All right, thank you. Can I come now to the structure of the Burswood subgroup, if I could call it that, the Burswood group
sure.
within the Crown.
Yeah.
Now, at one point, now I'm going to use my words, which I think encapsulates what you were saying, but if it doesn't, please let me know. At one point, and this was the question of really of the systems and areas and levels of responsibility. And at one point, I think you said that the fact that Burswood Limited might adopt a system that had been developed elsewhere in the group within the shared structure, the shared services model, didn't indicate an abrogation of the responsibility that the board of Burswood Limited had for that system. Is that a fair encapsulation of what you said?
Yeah, I think it is. I mean, essentially, the board of Burswood needs to be confident that whatever the system is actually meets their obligations.
Okay, now, can I put this proposition to you? That really depends on the capacity of Burswood Limited to have a say in the development of that system and the tailoring and the implementation of that system at Perth level, at local level.
Yeah, I agree. And what I'd say to you is that there are some things which are and need to be tailored to a local circumstance. There are other things which do not, and that is exactly the art of this, Commissioner. I once had a very dear Aboriginal doctor friend of mine say to me in slight frustration, this might be someone in WA actually, who said to me, it's not a matter of cultural practice whether I deliver the 3 measles, mumps, rubella shots at a variable interview. It's a matter of science and requirement. And so there are some things in terms of the national regulatory obligations, and I'm thinking particularly about AML-CTF here. AML-CTF, those obligations apply in a standard way across the country, right? They apply regardless of what kind of business you are. If you are caught within that regime, they apply. And you'll need to do things like reporting, IFDs, TTRs, et cetera, those things are standard. Now, there are, though, still sometimes differences in the regulatory regime in each state and territory. If there are differences, obviously Burswood needs to be accommodated in those. So does that make, I'm not sure I'm explaining that well, but you understand the point I'm making, I think.
But in the end, isn't it, doesn't it come down to a value judgment as to where ultimate responsibility lies?
I would probably argue with you slightly about that. What I would say to you is, and this is where the kind of goodwill and practice that I've seen operate, where actually you have a good level of accommodation across the responsibilities of a subsidiary, where they do exercise those responsibilities diligently and properly, as opposed to the needs of the corporation, the group. And so to say it's a value judgment, I would say that in every circumstance, you need to find that balance. You need to meet the needs of the subsidiary. And this is where I think I said to Mr. Futrell before, I don't believe they're inconsistent, to be honest with you. And there are obligations on the subsidiary, particularly in relation to the agreement. They are unarguable. So I think it is more than just a value judgment. Now, I would not say to you that I think where the line has been struck in the past is necessarily and I think Mr. Carter was going to this, I think the line needs to be discussed and agreed, and I'm not sure that that's been the case for a while. So I think this is quite doable, to be honest with you.
Do you agree with the proposition that the holding of a casino licence is a privilege?
I think I might have said that earlier on. Absolutely, I do.
And that it's a different sort of enterprise to many others, in that there are some inherent risks. For example, the harm, the potential for harm, the potential for criminal infiltration. So there are some inherent risks. And the licence is granted by a state government on behalf of the people, the community of that state.
Absolutely.
And it creates a situation where the licensee has a peculiar, using that word as I think you've used it,
Yes.
not as in strange, but in
Different. Yes. Yep.
that a peculiar set of obligations from that licensee to the community in which it is situated.
Commissioner, I completely agree with you. But what I'd say to you is, I don't think that, if it's discharged properly by a subsidiary, is inconsistent or in conflict with the role of a subsidiary in the broader group. And in fact, to the contrary, I think the licence, if it's done properly, can be discharged in a way which is to the advantage of the people of Western Australia, and to the very real responsibility given to the licence holder. One of the ways that happens is through the ability to actually understand in more detail, based on a broader group of operations, how best to deliver some things. Those are the things which I think we've already talked about might be more standard, as opposed to the things which are peculiar. We're coming back to that word, to the WA context.
But the situation in which a company like Crown finds itself is that it has, through one subsidiary, a peculiar set of obligations to one community, and through two other subsidiaries, it has peculiar sets of obligations to two other communities, which makes it different to something like, if I can use the ANZ as an example. ANZ is one business. It operates in states, and it has, as I understand it, advisory boards to connect it with with its communities. But it's a different situation. And go on.
Well, it has a subsidiary in New Zealand, which is a wholly owned subsidiary, which has regulatory obligations to the New Zealand government, to the Reserve Bank of New Zealand, where there are cultural and other expectations. In fact, we are the biggest bank in New Zealand. All
right, but just concentrating on Australia for the moment. This situation, so the situation that Crown finds itself in, I'll put the proposition to you. It makes it more difficult, not impossible, perhaps not even difficult, but requires a different attitude and approach than what is the more standard market view of the relationship between a parent company and subsidiary in an operating situation.
So, Commissioner, I endorse that view. It requires thought, it requires finesse, and it requires focus. So, no, you don't run this like you would run Woolworths, right? It is not the same. And even though you may have a Woolworths in WA who does a great thing with their local community, it is not the same as that. There is no doubt, it is not the same. I would say to you, and I'm very convinced of this, that it is very possible to run this business being mindful of the obligations owed to the people of New South Wales, to the people of Victoria, and to the people of Western Australia, courtesy of the privilege of the licence in each of those states, in a way which discharges those obligations properly and thoughtfully. But I would also argue to you that actually the people of those three states get a better deal by the opportunity of the group, as opposed to if these businesses were freestanding. But you're right, you don't stick it on set and forget. It doesn't work like that. This does require a level of understanding at all levels of the business of whose role is what, and if there are problems, how they're going to be resolved.
Yes, the purpose of my question was not to suggest that there should be 3 freestanding businesses, but simply that properly to discharge the obligations that each subsidiary has directly through the holding of the licences to the community requires a different approach. And that approach is, I'll put this proposition to you, that approach is sensitive to the degree of control which the subsidiary has over decisions that might impact on the nature of the relationship it has, the nature of the obligations it has to its community?
We could probably have a theoretical argument about this, Commissioner, in terms of who's going to be able to be sensitive to those needs. But what I would say to you is you do have to have sensitivity to those needs. I accept the contention that in a number of respects that those may be more able to be discharged if there is, and this is reflected in the Constitution, that there is absolute presence and focus on the needs of Western Australia in Western Australia. So I think I think it goes to the point that I made about regulators earlier on to Mr. Futrell. You know, we're regulating from a head office perspective heavy trucks up and down all across Western Australia, at least from a head office perspective out of Brisbane. Now, in truth, there are people in WA who discharge those responsibilities, but this is more than that. This is not the one uniform regime. This is not a regime where you can apply the same rules to everything all across the country. This is a world where there are rightfully different requirements and expectations, including of being a good local citizen, that come with the privilege of the licence. I think where we're sort of feeling our way around is how do you best achieve that, and how do you make those structures put some of that stuff in a balance, which is hard to disrupt.
All right, thank you. I have nothing further. Anything arising, Mr. Futrell? Ms. Thornton?
No re-examination, thank you.
Ms. Halton, thank you very much. I realise there are many calls on your time, and so making yourself available is where you have our gratitude for that and for your testimony, which has been of assistance to us. The situation is still fluid, so I'll leave the summons in place just in case. I doubt we'd need to speak to you again, but just in case. But thank you very much. We will now adjourn to 2 p.m. tomorrow afternoon.
All rise.